our first episode of this very exciting Law and Society talk.
Yeah, no, definitely. So sort of to give you a brief overview of sort of what this program is. So this is one of our most recent projects where we decided that really beyond the physical publication and our web presence, we decided we wanted to launch really a conversational component to our organization where we will in the coming weeks going forward bring to you discussions pertaining to recent case law, happenings from the steps of the Supreme Court and the federal circuits, and other projects and articles underway by our current writers and other contributors that we have. So we're really excited, and we thank you for tuning in and look forward to getting underway this afternoon. So I guess with that, we'll jump into a couple of things that we had slated for today. A lot happening really right now in the federal circuits and also at the Supreme Court level. Specifically, one case that caught our attention is Kahler v. Kansas, which I'm going to turn over to Matt now to sort of give a little bit of a brief overview and just sort of like why you think this is a significant case that we should be talking about.
Yeah, thanks, Ben. So this is a really interesting case. It was actually the first case of this term. And like Vin said, there's a lot going on the Supreme Court docket this term. It should be a very controversial term, and we'll talk more about what this term is likely to feature. But like Vin said, this was the first case, and the main issue in the case is whether the 8th and 14th Amendments permit a state to abolish the insanity defense. So as many listeners are probably aware, there is this thing in the criminal justice system, both on the federal and the state level, which is the insanity defense. And it basically allows a way for a person who may be insane to plead this special kind of plea called the insanity defense. So instead of being guilty or not guilty, there is this thing called guilty by reason of insanity. And what it is, it makes it so that you are able to plead insane and then go to a special mental hospital or an insane asylum and not be in the prison system for the rest of your life, where you might not be rehabilitated, because as you are probably aware, the prison system just isn't very good when it comes to mental health care. Mm-hmm. So the facts of this case are that in 2009, a man named James Kahler, he shot and killed 4 members of his family. So those people were his 2 teenage daughters, his ex-wife, and her grandmother. And this was during the weekend after Thanksgiving. So the background of the case is that James Kahler was married to his wife who had an affair. So this affair really got to him emotionally, and he became extremely distraught. He became extremely depressed. And what happened was his wife left him, and she took the kids. And he just became basically unhinged. So eventually he went to the place where his family was celebrating after Thanksgiving and killed, like I said, his 2 teenage daughters, his ex-wife, and her grandmother. So pretty interestingly, Kahler's young son was at the scene, but he actually ran out the back door and was not physically harmed. And Kahler actually kind of let him go because he thought that his son sided with him in the divorce. So those are the facts of the case. So he was charged with, I think, 4 counts of murder. And during this time when it came to trial, on trial, an expert testified that Kahler had been so depressed at the time of the shooting that he could not actually help himself. So this could probably help get a person off by not guilty by reason of insanity, except not in Kansas, because Kansas law says that Kahler could not argue he was guilty by reason of insanity because Kansas does not offer an insanity defense. So this might sound weird because you probably think that the insanity defense is universal across all states and the federal system, but actually it used to be. Although during the 80s, when Reagan was almost assassinated, what happened was many states were very hesitant of the insanity defense because of the treatment of John Hinckley Jr., who was the person who attempted to kill Reagan. He was not guilty by reason of insanity, and many people thought it just wasn't fair that he was able to almost kill the president and he went to a mental hospital instead of going to prison like everybody else. And interesting little fact, he's actually out of the mental hospital right now. I think he was released last year, 2 years ago. Yeah. So I think into the custody of his mother, I believe. But yeah, so what happened was in the 80s, a lot of states were just distraught by this verdict. So what they did was they tried to get rid of the insanity defense. And that Kansas did, and I believe 4 other states did, but the federal system and 45 other states have insanity defense. So, like I said, the main question is whether the 8th and 14th Amendments permit a state to abolish the insanity defense. And let's start getting into actually what this means. So I think this is the first really interesting topic, and Vin, I'll say a situation that Justice Breyer actually brings up. Mm-hmm. So Justice Breyer, during oral arguments, like I said, this was the first case argued at the Supreme Court this term. During oral arguments, he actually asked the people arguing for Kansas what would happen in the case of a dog. So the case of the dog goes like this. Say a man kills somebody who he thinks is a dog. Okay, so we'll call that case A. But in case B, a man kills a person that he believes to actually be a human being, but it was on the instruction of a dog. Okay? And we'll call that case B. In Kansas, what would happen, according to I believe it was the Solicitor General of Kansas, what would happen in Kansas is in case A, the person would be able to basically be not guilty by reason of insanity because they didn't technically abolish the insanity defense. They just really limited its scope to the point where Kahler's arguing that they abolished the insanity defense. So in case A, that person would be able to probably plead not guilty by reason of insanity because it's so restricted. But in case B, what would actually happen is that person would really not be able to plead guilty by reason of insanity because they still had an intent to kill another human being, even if it was on the instruction of a dog. So Vin, I was wondering if you could speak to that. What do you think about that situation? Do you think Kansas has it right here? Do you think that just because they had the criminal intent to kill this other person, even if it was on the instruction of a dog, that they should still go to prison? I was wondering what your thoughts were on this.
Yeah, no, I think that really raises sort of an interesting scenario because I think it's very hard to divorce, the sort of scenario with all of the complexities that surround mental health that really have a substantial impact in, how folks are deciding to act and really how, we're going to evaluate a remedy, right? So someone who is truly mentally ill that's going to commit something like this, putting them in a mental facility or putting them in prison, or even in some egregious cases, actually executing them and putting them to death, which there's other, case law that creates an additional layer of complexity there. Mm-hmm. But I think that's really a concern that I would have if you sort of buy Kansas's argument with that. And I also think even beyond the substance of the case law, looking at criminal justice policy and criminal justice approaches in general, this doesn't seem to really lend itself to one where we're actually trying to correct problems and sort of give people the opportunity to be corrected, if that makes sense, or rehabilitated, especially folks that may have mental disabilities or mental illness. So I really think that this opens up a really, really dangerous can of worms. I'm in looking at some of the notes that we had prepared for this too. I had noticed that there's other states that have also pretty limited, in some cases, defenses for insanity, which is also concerning because I think if the court ultimately endorses Kansas's position here, that can really open up the floodgates. A lot of other states that have a very sort of tough on crime, more regressive approach to criminal justice. So I think that's not only a question of law, but also has broader implications regardless of the ruling for the direction of criminal justice policy.
Yeah, you make a really interesting point because, like you said, the approach that Kansas really has taken is not one that really cares about rehabilitation. Mm-hmm. So it's kind of interesting to look at the dichotomy between what's going on in Kansas and what's going on at the federal level, because you had the First Step Act passed during this Congress, for example, where the goal is to try to first start to end mass incarceration, but really focus more on rehabilitation instead of just punishing people for committing a crime. So obviously there should be punishment, but at the same time you have to prioritize the rehabilitation so it doesn't happen again. So if you're looking at Kansas' approach, they don't really care about these people. They're putting them into prison, and either they're not getting. So if it's a really egregious felony, like for example, this person's not getting out of prison. Yeah. Okay, but you could still use the insanity plea for less dangerous crimes, and these people are getting out of prison and they're not being rehabilitated. So it's really problematic to what you brought up.
Well, and that's like one of the other things too that I think that you had raised before, which is a much broader discussion about like, how we really fail as a society, specifically within correctional institutions, to provide sufficient mental health resources for folks that have these conditions. And it really, I think a lot of people don't realize that even people that are incarcerated for extended periods of times for very egregious offenses, a lot of those people at some point are going to get out. There are some people that, yes, are serving life sentences, other people that are put to death, but really, a sizable amount of folks that commit these crimes will eventually see, the outside again. And I think one of the other questions, and this is, I guess, more sort of the policy side of me talking to me, that we have to ask is, if we throw the book at them, so to speak, and put these folks in facilities and sort of ignore that aspect of it, when they get out, they could potentially be equally as much of a danger to public safety, if not more, because of all of the other things that sort of compound when you're put into a correctional facility. So I think I'm in pretty much substantial agreement with a lot of what you said about how this really opens up a dangerous can of worms. I did want to move into the one specifically, like looking at some of the legal substance here. So the issue that the parties are raising here is that whether this approach that Kansas is forwarding violates the Eighth Amendment and the 14th Amendment, specifically as it pertains to permitting a state to abolish the insanity defense.
So do you want to talk about the Eighth Amendment implications of this?
Yeah, so I think that the clause of the Eighth Amendment that obviously here is most relevant is what scholars have called the Punishments Clause. So just to sort of read the Eighth Amendment for our listeners, the exact text: excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. And really that last clause there, or last section, is, I think, what really cuts to the core of this. And it's interesting because the history of cruel and unusual punishment has really developed, I would say, a lot in terms of case law over the last century or so. A big case, I believe it was Weems v. United States, which is sort of like one of the big Eighth Amendment cases where they kind of explored the meaning of that issue. But the history of the Cruel and Unusual Punishments Clause really goes back to a series of different historical episodes in England, specifically the English Bill of Rights, that basically has a provision that's virtually identical in language, at least as it pertains to cruel and unusual punishment. And to give a little bit of background on where that came from, there was an incident that usually most scholars will point to called the Titus Oates affair, or the Popery plot, which was basically an English clergyman during the 1600s, during the reign of, I believe, Charles II, had concocted this wild conspiracy theory that there were Jesuit-influenced Catholic insurgents that wanted to usurp the Protestant monarchy and install a Catholic strongman. Ultimately, there was a lot of procedural issues, but what had resulted from this was really sort of a mass hysteria. A lot of Catholic clergy and other folks that were implicated with these groups, because there were Catholics that were still in England at the time, even in political positions, had really roused up a lot of issues that resulted in people getting put to death, people getting scourged, put in prison, etc. But it was ultimately revealed that, later on, that this plot was a total hoax, essentially, regardless of the fact, rather, that James II eventually ascended to the throne and was a Catholic who was not necessarily kind to Protestants. But it was the punishment and the follow-up to Titus Oates that really was a cause for a lot of concern in England and eventually the founders, because of what he was sentenced to. And if I'm looking at my notes here, some of the things that they had basically sentenced him to was life in prison, being scourged, and really things that were seen as disproportionate to, or disproportional to, typical sanctions that would be imposed for a crime like this. So again, things like life imprisonment, whippings, defrocking, which was interesting because he was a clergyman, which there was issues about, like, can the English state do that, and an exorbitant fine. That as sort of a background, and a couple of other historical episodes really carried over into the founder's mind, I'd say, about this idea of proportionality in punishment, which is still, I think, relevant in our discourse today about punishment. It's like, are we sentencing people, in accordance, with, what we think is the proper remedy for what or rather the proper punishment in light of what they committed. So I think that's an important frame to sort of keep in mind, is that there is, at least historically, a tradition rooted in proportionality. Some of the case law has really expanded on some of these understandings and gone into other areas. But I do think still that the history here is important, especially when you consider someone who has mental illness, knowing that, they may not necessarily have had, the capacity to, like, actually understand what they were doing. The example that you gave with the dog, the hypothetical scenario from Justice Breyer, I think that really speaks to indirectly this idea of proportionality. Like, is throwing the book at someone in a severe way that has a severe mental illness, is that really proportional? I'd say no.
And what purpose does it serve, right? They didn't even know what they were doing. What purpose does, if it's supposed to have that deterrent effect, then obviously it can't have a deterrent effect if the people don't even know what they're doing. Okay. So, obviously, whether it's proportional, I really don't think that anybody could say that, or at least in my opinion, I don't think it's justified to punish a person who had no capacity to even really understand what they were doing. Pretty interesting in this case, though. The interesting thing about this case coming to the court was that James Kahler, based on the facts that I discussed at the beginning, probably did understand what he was doing. And interestingly, the justices point out that even if Kansas had an insanity defense like other states and the federal system, it's not likely that a jury would have found him not guilty by reason of insanity. And the reason is number one, I mean, he let his son go, first of all. Like, he knew that he knew right from wrong based on the idea that he killed the people that he didn't like, and he let the person go that he did like. So, I mean, there's a really good argument that even if Kansas had a actual insanity defense, he probably would not have been able to plead not guilty by reason of insanity. And that actually brings up a really interesting point that I actually read the amicus brief that the ACLU filed in this case, and a point that they made is that a lot of people are scared of the insanity defense because they have this idea of these people, like these people who just murdered somebody. They go to a mental hospital for 6 months to a year, and then they're let back on the street, and they go to recommit crimes. And that's just not the reality of the situation. It's the insanity defense, first of all, is not used very frequently, and when it is used, it's not successful very frequently. So. And not only that, but the rehabilitation tends to work. So you don't have these crazy murderers getting out of the mental hospital and going back to recommitting crimes. So, I mean, so while I said this case is really interesting and important, it's not something that's being used a lot. It's more niche than a lot of people would imagine. It's used very infrequently.
Yeah, and I think from more of like a broader level too, I think it speaks volumes that organizations like the American Psychological Association have filed also amicus briefs, really trying to outline why this is an incredibly dangerous shift as it pertains to criminal law. There was a quote here from their website that said that the APA joined with the American Psychiatric Association to file a brief arguing that the constitutional due process rights are infringed by not allowing mentally ill defendants to present a traditional insanity defense. And I think that your point is really significant and is really lost on some people. That, I mean, the natural reaction is, we want people to be safe. I mean, that's, I think, at least at its core, the impetus for a lot of criminal justice policy in general, even just sort of approaches to criminal law. But really what this does, I think, as you've outlined, is put the rights of those who this would truly protect really at risk, which I think is a substantial issue.
So lastly, before we move on, I think we kind of touched on the Eighth Amendment. You gave a really nice background, and we talked about that a little while. But we should probably touch on the due process argument.
That's what I wanted
just
to
real quick. So I listened to oral arguments, and a lot of it, there wasn't a lot of focus on the Eighth Amendment. It was mostly focused on the 14th Amendment, and it was a very long back and forth fight about the history of the insanity defense, because the basic argument is if the insanity defense in this right and wrong test that most states have, saying that if a defendant doesn't know right from wrong, then they really shouldn't be held liable for what they did, is that so ingrained in American society that by Kansas abolishing it, it becomes a violation of the Due Process Clause. So there was just really a lot of back and forth about whether this right and wrong test was so ingrained in society, and so the Kahler side would come up and bring up a couple cases, and then the justices would say, oh well, in this case, the right and wrong test wasn't there, and then Kansas would get up and they would say, oh well, in some of these cases the right and wrong test wasn't present. So it was just it was really dense argument when it came to the due process arguments. And lastly, and it's pretty interesting, you brought up Great Britain. I mean, the right and wrong test really has a pretty is really rooted from Great Britain when, and I believe it was the 1840s, a man named Robert, I forget the man's name. I thought it was Robert Peel, but I could be wrong.
That's interesting. So continue.
Was he the man, or was he the prime minister at the time? I forget exactly what it was.
I believe he was the prime minister.
Yeah, I think he was the prime minister. There's a man. Oh, it's Monodon. That's of course I know. Yeah, sorry. There's a man named, I think it was Robert Monodon. He tried to kill Mr. Peel, and he missed and killed somebody else. But the point was that Monodon thought that Peel and others in the British government were out to get him, and the House of Lords eventually ruled that because he was just so deluded, he didn't really know what he was doing, and he was coming up with these conspiracy theories, and he was just way out of his mind, that he really shouldn't be held liable for the crime. So, I mean, that's where it comes from, and then whether that's really ingrained in American society, I mean, it was part of the criminal law for all 50 states and the federal system for years, but I mean, I don't think since the founding. So, I mean, there's arguments on both sides, but it's a pretty interesting question. So, when it comes to what's going to happen here, nobody's really sure. So the experts really don't know what's going to happen. Obviously, we'll get a decision probably by June, probably before then, because it was the first case argued. But I mean, Breyer is probably going to side with Kahler. But this is one of those cases where we don't really know. Like, it's not ideological like some of the cases we're likely to talk about on this show in the future. So we might see some conservatives end up with Breyer. We might see, I mean, it could be, nobody knows is the point.
Yeah, that part I'm particularly interested in just before we move on, because specifically constitutional issues or even just cases that involve criminal justice procedure have always been really interesting on the conservative side of the court. Justice Scalia wrote several very, very strong opinions that he was joined by many of his liberal colleagues on the court, as it pertains to the rights of criminal defendants. So I think that this is far harder to sort of, I guess, anticipate in terms of, I would say that even just looking at some of the recent decisions, like in the Flowers case, for example, that dealt with death penalty, like Justice Kavanaugh wrote the majority opinion in that. And I think it's safe to say that Clarence Thomas may sort of be in the dissent. Sometimes he takes a far more narrow view of these provisions. But criminal procedure seems to be a little bit more of an outlier when it comes to anticipating where the justices are going to rule. So I think that's going to be a very interesting case, not only with seismic proportions as it pertains to criminal law, but also just really interesting to see how, the ideological makeup of the court will, sort of determine where these issues, how far these issues go. And what's the proper remedy. So I guess with that, we'll move into some of the other cases that we had slated for today. As everyone probably knows, there's no shortage of news with the Trump administration and its battles with the House of Representatives and its respective committees. And there's been a huge debate going back and forth, especially in major news headlines, with regard to the disclosure of the president's financial records and tax returns. And two cases in particular caught our eye, so I'm going to also turn it over to Matt to sort of discuss one of the major ones. We'll begin with Trump v. Mazars.
I think it's Mazars.
Mazars, yeah.
So we'll kind of talk about these together in a way. So I'll kind of brief the issue more broadly, although you did a very good introduction. So ever since last year, there's been this push to get the president's financial records. I mean, we've been talking about it for years. The president said that he would turn over his tax returns, and then he said he wouldn't. This was during the campaign. And eventually, I mean, he said he was under audit, except we're not really sure if he's under audit. But the point is, he didn't turn over his tax returns, and he was the first president not to since, I believe, Richard Nixon. I believe all presidents after Richard Nixon released their tax returns. So, I mean, obviously, there's no law saying that they need to, but it's just become standard practice. Anyway, the president is a president with a significant amount of business dealings, a lot overseas, and obviously there is this want to really know what's going on with this president's financial dealings. So we'll start with Trump v. Mazars, like Vin said. And this one involves the House of Representatives. So last year, in January, the House of Representatives formally changed to Democratic control, and with that came subpoena power. So a couple months after the Democrats formally took control, they decided to subpoena President Trump's accounting firm. And this is really important. They did not subpoena the president himself. They subpoenaed the president's accounting firm, Mazars, for I believe it was 8 years of records. I'm not sure if Mazars probably has his personal tax returns, although I don't think they asked for his tax returns specifically. But the point is, they were going to his accountant. And ever since the House of Representatives filed this subpoena, Trump has been fighting it, obviously, because he does not want the House of Representatives to get their hands on these records because of, we don't know if there is malfeasance in there or he just wants to keep his business interest proprietary. We're not exactly sure, except that he really does not want this to become public, so he's been trying to stop it. So anyway, the case mostly focuses on whether there's like a legislative purpose for the subpoena, and Trump's argument is that the subpoena is about law enforcement. Okay, so that's not typically Congress's role. The executive branch is the one that deals with law enforcement. Meanwhile, Congress's argument is that their purpose for getting the president's financial records is they want to review the federal ethics and government laws, which makes sense. There's this idea going back to really Trump's inauguration that the president should not have business dealings while he's in office because it creates all of these conflicts of interest. And for example, you have many, many, many people staying at the Trump Hotel in Washington, D.C., trying to curry favor with the Trump administration by spending thousands and thousands of dollars at his hotel in Washington, D.C., or going to Mar-a-Lago or one of his many other clubs around the world. So, obviously, I think there is, and there was this idea that this really shouldn't be allowed, and Congress is really looking at these ethics and government laws. So whether we believe that to be true or not is a different question. But the courts have so far said that it's really not their role to really strongly oppose what Congress says is their purpose, and that's why Trump has lost at every stop so far. So he lost at the district level a couple months ago, and he appealed to the D.C. Circuit Court, where he lost 2-1. Interestingly, the one dissent was Judge Rao, who is just confirmed to the Circuit Court to replace Justice Kavanaugh. So, So after that, Trump then requested a rehearing en banc, and he was denied, so he's trying to get help from SCOTUS. We can go back. I'll talk a little bit more about what's going on with that in a second, but we should probably real quick jump into Trump v. Vance, which is also very similar. So in this case, the New York County District Attorney Cyrus Vance, so this is local or state, but it's not federal, is my point. He issued a subpoena to Mazars as well. So Mazars is just really inundated with litigation, although they're not like the primary party litigating these. This DA issued a subpoena to Mazars for financial records, the same financial records, and this was the reason he issued the subpoena was that it was part of an ongoing state grand jury proceeding. Okay, and what they're investigating supposedly is whether the Trump organization falsified business records to disguise hush payments to 2 women who claimed they had sex with President Trump before he took office. So they're investigating the same thing that the Southern District of New York was investigating a couple years ago. And the arguments behind this are a little bit more ridiculous in the eyes of many legal experts. This case made national headlines last month, or maybe even earlier this month. And you probably remember this, Vin. It's when in the appeals court, Trump's one of the judges asked what would happen if Trump shot somebody on Fifth Avenue.
Yep.
Yeah. So I mean, it made national news because what Trump's lawyer said was that nothing could be done.
Yep.
Not only could the president not be prosecuted, which is an interesting question, I think a valid, point of disagreement whether the president could be prosecuted while in office. What the president's lawyer said was that not only can he not be prosecuted, he can't even be investigated for shooting somebody on Fifth Avenue. And this kind of stunned everybody, even the judges at the circuit court. They were really surprised. So, unsurprisingly, he lost unanimously at the circuit court. It was the Second Circuit. So then he's trying to, I believe he already filed his, I'm not sure if he formally filed his writ of certiorari yet. His petition for certiorari, sorry. So that's what's going on in that case. And we could say, so the heart of what's going on is whether the president can not be criminally indicted while in office. That's kind of the argument that the Trump lawyers are saying. And they're arguing he's absolutely immune from criminal process during the same time period. So not only can he not be prosecuted, he can't even be involved in the criminal process at all at the state level or the federal level. And we'll get more into this, but I think it's a pretty interesting question, especially in light of Clinton v. Jones in the 90s that had to do with a civil case. And it comes down to whether these proceedings would burden the office of the main reason why a lot of these processes you're not allowed to have some of these processes because the president can't be distracted with all of these different court cases. The president has to deal with the entire executive branch. We need the president to really be focused. And if they had to sit for countless depositions and had to be meeting with their lawyers all the time to do X, Y, and Z, then that would really burden the office of the presidency. So that's I think that's the argument, and we can go back and forth on that. Yeah. But that's basically the two cases, and they're both at the Supreme Court level. The Vance case was extremely fast. I mean, we're talking about Trump filing his complaint, I think, in mid-September, and we're already at the Supreme Court. And as you know, Vin, and as many listeners know, some of these cases take years. I assume in coming weeks we might talk about the Title VII case. I think that Title VII case started maybe in 2013 or something like that. Yeah,
because it made its way through the federal circuits and then eventually got up to the court.
It takes years. So this one's really fast. And it makes sense because this involves the President of the United States. But before we get into actual talking about it, what's going on in the first case, the Trump v. Mazars case, is it should be pretty interesting. And the next time that we actually record, we may have an update on this case because the Supreme Court right now is deciding on whether they're going to issue a stay of the subpoena. So we might hear Monday, actually, what's going to happen with this. So if they issue a stay for the subpoena, they need 5 votes out of the 9 justices. If they issue a stay, then they probably will grant cert, and they'll hear that case probably very late in this term. So it's going to be many months till we hear. But if they do not grant the stay and the subpoena is allowed to be enforced, then that's basically it. I mean, if the House of Representatives is allowed to enforce the subpoena, then Mazars will comply and they'll give the records. So, we might know what's going to happen with this case in the next couple of days without even it being fully briefed and argued. So that's that case. And the second case, the Trump v. Vance, we're supposed to hear probably soon as well, but not as soon as the House of Representatives case. But they're asking for cert right now. So, we could jump into this.
Yeah. One of the things that I thought was particularly interesting that you raised is, specifically with the Vance case, there's far more of a clear sort of concern with the idea of prosecuting the president for potentially, violating laws relating to hush payments, et cetera. Whereas the other one, at least the way that you described it and the way it's sort of being framed, I think it's very crafty by the House of Representatives lawyers, is that it's not necessarily, at least explicitly, with the intent of, ultimately prosecuting the presidents. It's to inform, like you said, development of other federal ethics laws and statutes to prevent some of the things that are a valid concern from happening in the future. So I think that, do you think, based on those two things, at least from my perspective, I think it's a far harder case for Cy Vance to win, because he's, really kind of pursuing a criminal investigation. And there's, like you had pointed out, a lot of disagreement, not necessarily even on political or ideological grounds, but really just within the legal community as to whether you can indict, investigate, or prosecute a sitting president while he's officially the president. So do you think would you agree with that like the Cy Vance is going to have a far harder time of probably being successful on his suit as compared to the House suit, or do you think they're sort of both on, it's too hard to tell?
Yeah, so you raise an interesting point. So I'm not sure exactly which one's harder, and I think the reason the Vance case might not be as hard as you think is because this isn't about prosecuting; it's about investigating. So,
yeah.
I would like to hear your opinion on this, regardless of what statute says right now. Does it feel wrong to you that the president might be precluded from even investigation at all? Like, it just doesn't seem right that you can't we need to leave the prosecuting or even indicting aside. What about investigating the president?
Yeah, I grapple with that, and honestly, I think it's kind of hard to divorce investigation from ultimately the resulting prosecution, and I think that's where a lot of the issues are lying, because that's, at least I think from a lot of people's perspective, the logical follow-up to an investigation. Because in theory, in one world, if you had allowed, sort of a period of investigation to occur, whether it's criminal-related activity or other things, that could still have a very dampening effect on, the president being able to discharge his responsibilities, like you pointed out before. I do think that at the same time, though, I'm not personally comfortable. I think a lot of people are uncomfortable with the idea that the president could, in fact, go shoot someone on Fifth Avenue and not even be investigated. Like, we can't even, investigate that incident as occurring, even if it was abundantly evident that he did it.
No, you make a good point.
And I think it's, at least from my perspective, I think it's very hard to divorce investigation from the ultimate prosecution. Although,
that's valid.
I do think it's not necessarily a done. For example, in Clinton v. Jones, I believe in that case they allowed the president to be deposed.
They did.
Which was, there's significant controversy over whether the court had sort of erred in that regard. But there is at least precedent for some things relating to the ability to investigate a president, albeit that circumstance was a civil suit.
Yeah. And federal.
Yeah.
It wasn't. Yeah,
civil as opposed to criminal.
Yeah, I forget exactly where it was, but it's a little bit different. But you make a good point.
Yeah.
Something that's pretty interesting is what you said about separating investigation from prosecution. And I think you make a good point. It was what's happened in the Mueller investigation, where the Mueller wouldn't even say whether he thought that Trump committed crimes. What happened was he kind of left it up to every reader to decide, because he was just so uncomfortable with saying that the president committed crimes, but they can't go to court because of the OLC memo. The president can't be even indicted. Although, could the president be indicted under seal for a couple years? It's just, I think it makes a lot of people uncomfortable, the idea that the president can't even be investigated. And I firmly do believe that the president, indicting is separate. Although we just saw, I think it's pretty interesting. We're talking about this now, and I'm sure you saw, Vin, and I'm sure a lot of our listeners heard that Benjamin Netanyahu in Israel this week was formally charged with multiple different counts, and I believe he's still the sitting prime minister. They're going through chaos right now, obviously. In Israel, but they have a pretty interesting system over there, and I think a lot of Americans were looking across the ocean and being like, well, that kind of makes because it kind of makes sense, but at the same time, I understand the problems there are with prosecuting. But you kind of mentioned the burden on the office of the president, and I just want to note something I said at the beginning. Remember, these subpoenas aren't being served to Trump personally. They're being served to his accountants. Yeah. So that's where, if I believe it'd be a lot closer if it was being served to Trump personally. But because it's being served to his accountants, there were arguments how does that burden Trump himself or the office of the president at all? Because they're not even going to Trump or the office of the president. They're going to his accountants in New York. It doesn't burden him at all. But Trump is trying to say, I can't be investigated. So I mean, I think you make a really interesting point. I'm not really sure. A lot of legal experts don't think there are good arguments in either case, and I'm not very persuaded by either personally. I mean, I'm not sure. I mean, like you said, I mean, you never know what could happen with this Supreme Court.
I mean,
he's lost at every single level so far.
I think that, at least from the House's perspective, if I had to like put if I was a betting man for either one, I think the House's suit would have probably more of a chance of success, only because even if you buy into, the prevailing, approach right now, at least as the Office of Legal Counsel at the Justice Department is concerned, that you can't indict a sitting president, that power is, at least as it pertains to investigating the president and investigating wrongdoings, does still rest in Congress's lap. That is a responsibility and a power that they have. So even for the people that say that, there's not
in the view of Trump, though.
That's he's a very special, I think, variable in this whole consideration. But I think the response, though, from a lot of people that say, well, it doesn't make any logical sense that we can't, indict, prosecute, or even investigate a sitting president. And then I think the rebuttal to that as well, we can, it's just procedurally different. It's that instead of a prosecutor and a petit jury or a grand jury doing it, it's Congress that does it, that you have the impeachment process serves as basically the indictment, and then the Senate trial, basically the Senate is the jury.
Yeah,
and then after the president if the president is removed, then, action can be taken by respective prosecutorial or law enforcement authority to then prosecute those matters. So I think
that's a valid argument.
It's a very interesting. I think that the idea on a very broad scale, the idea that a president can't be held accountable, that the president is somehow above the law, I think that notion is false. But I think when you go down a layer deeper, it's just a matter of what tools and processes have to be used in order to arrive at holding a president or a sitting officer accountable.
Yeah.
One thing that was, I think, particularly interesting that I think is germane to this discussion, albeit slightly different, was the California Supreme Court's recent decision, which I think was actually earlier just this week, that California had...
You're talking about the tax returns?
Yes, had a statute that would basically require people running for president or to be in the presidential primaries in California to submit their tax returns and certain financial records to the Secretary of State in California to be reviewed. And what's interesting is that the California Supreme Court struck that down. And it was really in sort of legacy or whatever term is proper here of all these cases and losses that Trump has been dealt. It's interesting that the California Supreme Court actually, handed him a win, at least in this regard. It's really in many ways different than I think the broader federal discussion, because this deals specifically with the state statute, the California state constitution, and really the California state primaries, which I think Trump even said that, I'd rather forego the California primaries than hand over my tax returns.
I believe it. Yeah.
But I found that sort of like interesting as well, that, they still involving, the notion of should presidents or people running for president be compelled to release their financial records, and whether that creates other legal concerns. So I thought the California case was particularly interesting. I'm not as well versed on the substance of the law. Yeah, I should read that.
That's really interesting. Lastly, before we move on, I was wondering, and this is kind of Supreme Court politics almost, something that's pretty interesting. Do you think the court wants to get involved? Roberts has a reputation for really not wanting to get involved in a lot of these different cases, although the counterpoint is, he tries to get out of these really political big cases, but like I said, the travel ban was, I think, 2 terms ago, I think it was 2 terms ago. And then the gerrymandering case from last term, the census case from last term, during this term, and we'll probably talk about this in the next couple of weeks, the DACA case, the Title VII discrimination case. So, I was wondering, what do you think? Do you think he's going to want to get into these cases? Especially because the first case involves, separation of powers, a pretty fundamental House of Representatives versus the executive branch. Well, not technically executive branch, but the office of the president.
I'm inclined to say that probably not, that they don't want to get involved in this. Now, whether they will get involved in it or not, I think is an additional question. And that I don't ultimately know the answer to. What I do know is that what I think Justice Roberts and the court has in their arsenal of tools is that, even if they grant this stay or sort of grant there's obviously with those rulings, an opportunity for argument in the future. And I think what they can potentially do is delay that argument as long as possible, whether it's until after the election or at some other timeline, so that basically if they rule on it and they rule on the substance of law, it won't be treated as a political case that can undermine the legitimacy of the court. I think that that's probably, I don't necessarily know if that's a likely scenario, but I do think that that is probably something that they would consider, knowing that just getting involved in this realm is going to be politicized, because they rule in Trump's favor. The left is going to try to discredit the court as being packed with conservatives. If they don't rule in Trump's favor, then Trump and Trump's allies will launch a political attack on the court and try to undermine its legitimacy. So I think they're really in a lose-lose situation.
Oh, 100%. Yes.
So I think that really one of the opportune, tools that they have, if they choose to use it, will be to try to delay arguments for this as long as possible. Because, say, for example, and this is bringing another conjecture, that Trump loses the 2020 election, then basically this case, I would imagine, even if it's not procedurally moot, will pretty much, will be rendered to relative 100%. Insignificance.
Yeah, very much.
And I think at that point, other cases that are prosecuted by, like, DAs like Cy Vance in New York, or even other, federal investigations, depending on who wins the election, those will take a front seat in, sort of these discussions if, it continues to go that way. So I think that the court will try to delay argument for this as much as possible.
Yeah, it's valid. I didn't see many people saying that. Everybody was pretty sure that they would just get thrown on at the end of the docket, like the end of the year. But, you could be right. And that's a good idea, honestly. But, at the same time, like you said, it would be moot if it was after. Like, what's the point?
Yeah.
Although, if the law is more important than getting
of course,
hands on this. But anyway, we could probably move on to
of course.
the next topic. I was wondering if you could kind of speak to the SAFE Act and the States Act.
Yeah, so just sort of to give a little bit of an overview to our readers, to our readers that are listening, but also our listeners, I guess, immediately, is this sort of broader discussion that's been going on. It's really become a significant issue, I think, in the 2020 election, is this idea of marijuana law enforcement, and that there's a lot of, really over the course of the last decade or so, there's been pretty noticeable movements in one direction or the other as it pertains to drug enforcement. So for those that may already be aware, I'll just give sort of a little bit of a backdrop as to what marijuana policy has looked like over the past couple of decades and where we're currently at now. So marijuana or cannabis is currently designated as a Schedule I substance under the Controlled Substances Act, which was effective as of 1971. And this is really, I'd say, one of the chief laws that you can associate with the war on drugs, and is really where a lot of the prosecution for drug offenses, that's usually where that statute gets pointed to. So this, as many of you know, means that basically cannabis is functionally illegal in most cases across the board, at least at the federal level, barring certain and typically rare exceptions, mostly pertaining to very limited research by approved institutions and laboratories. I don't know this for a specific fact, but I do recall that of the university institutions that were allowed to research medicinal uses for marijuana, I believe it's one university in Mississippi.
That. I actually do remember.
And even within that,
it's grown in one place or something.
Yeah,
right?
And even within that university, if it's still the same place, there's one guy who's in charge of that has federal approval to research.
I've read that. Yeah.
And even then, there's a Kafka-esque bureaucracy surrounding the processes for researching medicinal marijuana, even just marijuana in general, because it's been very, very hard to do that under the Controlled Substances Act for a litany of reasons that kind of go beyond this discussion. But generally, under the CSA, drugs are scheduled according to the level of risk they pose for severe physiological and or psychological abuse or dependency. And really, as we pointed out before, debate has ensued for decades over marijuana's designation as a Schedule I drug, which is the highest tier. So you have Schedule I, Schedule II, Schedule III, and there's sub-tiers under each of those as you go further. I actually don't know if Schedule I has sub-tiers. I know Schedule II and Schedule III do. But really, the debate is centered over, really is marijuana, a dangerous substance with a high dependence liability to really justify Schedule I designation. So under Title 21 of the U.S. Code, Section 812, Schedule I substances, which again what marijuana is under, are described as having the following characteristics from the law. So the drug or other substance has a high potential for abuse. The drug or other substance has no currently accepted medical use in treatment in the United States, and there is a lack of accepted safety for use of the drug or other substances under medical supervision.
Sounds very outdated.
Yeah. Well, what's interesting, too, is that I think this is where also the law that we're about to talk about, where a lot of this comes into, is that there's a discussion of, there's other drugs that are arguably far more dangerous, that have far more tangible, documented health side effects and dependence liability, et cetera,
Give an example.
that are actually not scheduled under Schedule I. I believe, so up until, there was talk about changing this. I actually don't know if the Congress had officially passed this amendment to the CSA, but for a long time, cocaine was under Schedule II, I believe. Wow. Which obviously is very, very dangerous in a lot of communities and has destroyed communities. And really, it was a question is when you're comparing apple to oranges, really, like where you're looking at something that has had noticeably devastating, effects on communities, and that ultimately is health-wise much more dangerous.
Oh yeah.
Under a lower designation, at least under the CSA. So there was, I vaguely recall, and I don't have the specifics on this, a resolution or a bill that I believe originated in the House of Representatives to reschedule cocaine under Schedule I, which I think makes sense if under that that logic, if you're operating under what the CSA says as its criteria for scheduling drugs. But I don't know if that's gone through yet. Regardless, according to Business Insider, despite federal prohibitions, we have 10 states as of this recording that have legalized both recreational and medicinal use, and another 20 separate states have legalized in some form or another use of cannabis for medicinal purposes. So there's a really interesting development, as a lot of you probably know, where there are states that have passed resolutions and laws to legalize, decriminalize, some combination thereof, marijuana in some capacity or another, which is, it's a lot. 30 states have these laws on the books in varying capacities. But the Justice Department still continues to enforce the CSA because it's federal law.
Like the weird dichotomy between like it being illegal on the federal level, except a lot of states are doing it. Anyway. Continue.
Yeah. And I think what's important to point out here, too, is that because the Justice Department is the one that's really principally enforcing these laws, so you have the Drug Enforcement Administration, or the DEA, which is a sort of group of the broader Justice Department that really is in charge of investigating and pursuing a lot of these matters, at least as from a law enforcement perspective. And the Justice Department obviously prosecutes violations of those policies. But really, by virtue of that office being to an extent subject to who's in office at any given time, there's been significant variation in the enforcement of this policy, I'd say really over the course of the last two administrations.
Oh, yeah.
So under the Obama administration, for example, there was a famous directive that was given to the Justice Department. It's now called the Cole Memorandum, or the Cole Memo, that roughly stated that given its limited resources, this is the Justice Department would not enforce federal marijuana prohibitions in states that, quote, legalized marijuana in some form and implemented strong and effective regulatory and enforcement systems to control the cultivation, distribution, sale, and possession of marijuana, except where a lack of federal enforcement would undermine federal priorities, such as preventing violence in marijuana cultivation and distribution, preventing cannabis impaired driving, and preventing marijuana revenues from going to gangs and cartels, which I think is like a sensible sort of stipulation.
Seems pretty sensible to me.
What I found interesting is that like they're kind of the way that the Cole Memo kind of like lays this out is they're kind of to use language, it's almost like a kind of a half-ass approach. Like if I'm putting it in strict layman terms, because what they're really saying is that we don't have enough resources to really meaningfully pursue all these cases, which to an extent I think is true. Like it costs a lot to prosecute those cases, but at the same time, it seemed that in the Obama administration and in a lot of other sections of the Justice Department at that point in time, there was this idea that these laws, like you said, are outdated and that we may need to take a different approach. The problem is that the Justice Department can't unilaterally amend the CSA. Congress has to do that. But enforcement is still largely discretionary from the Justice Department's perspective. What's interesting is that this memo, the Cole Memo, was ultimately rescinded by the now former Attorney General Jeff Sessions, who's no friend of marijuana, said in hearings in the Senate it when he was on Capitol Hill that I think only bad people smoke marijuana.
Yes, I remember that quote. Yeah.
And really just sort of keeps in this general theme with the Trump administration that they're more, sort of the philosophy of strict law and order, strict enforcement of the law, specifically when it comes to drugs. So really what this is all created, and this is a very big background to the ultimate statute, is that there's a lot of uncertainty and inconsistency with regard to CSA cannabis enforcement, really coupled with meaningful and stronger campaigns for reforms for marijuana laws, some stemming from civil liberties issues that, basically, if things like tobacco and alcohol are illegal, that, we should have the right to do this if we're, doing it responsibly and as adults. But there's also the broader context of criminal justice policy and the war on drugs, which is these laws, not even just marijuana enforcement, but drug laws have made a significant contribution to, burgeoning mass incarceration over the last several decades. So really, I think what there was a need for was a more thorough legislative solution, to come to the fore, really, to try to address a lot of these solutions. So I think with that, we can move now into discussion of the States Act and its component SAFE Act as well, which sort of proposed as not an amendment. I actually don't know if it was an amendment to the act or just a standalone act that complemented the States Act. But the States Act is actually an acronym like the Patriot Act that is strengthening the 10th Amendment through entrusting states. And what's interesting is that this bill was proposed in the 115th Congress and would recognize legalization of cannabis and the U.S. state laws that legalized it through their legislatures or citizen initiatives.
So that was last Congress.
What's interesting, too, is that this bill originated, to my knowledge, in the Senate, and it was actually co-sponsored by Senator Cory Gardner, who's a Republican, and Senator Elizabeth Warren from Massachusetts, who's a Democrat.
Quite the duo.
Yes.
Yeah.
And it makes sense from Cory Gardner's perspective because Colorado is one of the states that was one of the first.
I think it was the first.
I believe it was the first, to legalize recreational use of marijuana. Yeah. And then also, as I had mentioned before, there's a companion bill that was introduced the same day in the House of Representatives that was sponsored by Earl, I'm going to butcher his name here, Blumenauer, who's a Democrat from Oregon, and David Joyce, who's a Republican from Ohio. So sort of from the get-go, this issue is not anymore at least a partisan issue. I think the approach and the implementation still has some partisan elements, but there seems to be a growing consensus that a lot of these laws have outdated elements to them and that there's this real issue, especially the Justice Department, of how are we going to enforce this? And what makes the most sense. And so basically what this act does, among other things, is amends the Controlled Substances Act of 1970 to exempt from federal enforcement individuals or corporations in states who are in compliance with U.S. state, U.S. territory, and the District of Columbia or tribal law on cannabis with certain additional provisions such as minimum ages.
Okay.
So it's kind of multi-pronged here. What they're trying to do, I think, that's one of the major differences in, I guess, historical drug policy is that they want to try to acknowledge that some states have determined, given their own localities, their own circumstances, that we don't think that prosecution of marijuana laws really is good for any number of reasons, and that if you can garner enough support to get a law passed through your state legislatures, that that law should be respected, and that you shouldn't have federal encroachment to try to disrupt that state policy.
Yeah, so couching in states' rights terms for the Republicans.
Exactly. Well, and that's what I find particularly interesting here is that I mentioned that there was bipartisan co-sponsorship in the Senate. There is bipartisan co-sponsorship in the House. Yeah. And there's, I think, at a certain point, I don't have. Oh yeah, so here's the stats. So as of September 18th, 2019, the House bill had 206 co-sponsors, and the Senate bill had 33 co-sponsors.
Wow,
and
that's a lot.
There's, I actually don't know what the number breakdown is, if there's actually more Democrats than Republicans, but there is a sizable. It's not just like one or two Republicans that. Have co-sponsored this.
Yeah, I saw Rand Paul, I think, was on there. And that makes sense for Rand Paul.
Yeah, McClintock in the House, who's a representative.
Collins or Murkowski, which is not surprising.
Yeah, no, Collins, I believe Collins is a co-sponsor on the House side. And McClintock, who's a little bit more libertarian-esque from California as a Republican, also, I believe, is a co-sponsor. And again, it's with this idea of, there's I think a question here in the title alone with enforcement of the 10th Amendment, that there's this prevailing, logic that, the states do have a role in, maintaining their own business to an extent without the burden of the federal government coming in and messing things up.
So I saw that Trump actually said he was not opposed to the legislation. I was wondering, do you know? I mean, I know it didn't go anywhere.
Yeah.
I mean, they tried to make it go places. It just didn't happen.
So to my knowledge, this is still sitting. I actually don't know if it's been reported out of the Judiciary Committee yet, because this is in Judiciary, it's in Transportation, and I think Energy and Commerce as well. Because there's the bill itself, that's the general sort of synopsis, but also makes specific provisions and limitations for, again, things like trying to prevent revenue streams going to criminal syndicate organizations. And also, the SAFE Act, which was proposed as a companion bill, what they would do is it amends some of the banking procedures, because one of the major things is that in a lot of these states, such as California or Colorado, you can't actually receive a lot of business loans and a lot of other financial paperwork and things that you need, because those institutions and banks in general can't bankroll things that violate federal law.
That makes sense, yeah.
So a lot of these businesses are cash businesses. They're subject to different tax guidelines. One of the interesting things, too, about medicinal marijuana, which has become a major issue in some states, is that a doctor can actually prescribe you marijuana. So what they can do is they can refer you, which is technically different. Under federal law, doctors can't obviously can't prescribe you something that is illegal or that is something that contravenes federal law vis-a-vis like the Controlled Substances the Controlled Substances Act. So there's also questions too as to in states where it's determined that medicinal marijuana could have potential medical benefits, a doctor really can't prescribe it. They can refer you, and that also creates additional issues with where they refer you to. Because it's an illegal substance and there's not a ton of regulation, there is in some states, but because there's not as much of a regulation on production, distribution, maintaining marijuana, that you could be referring people to take something that may in fact be dangerous. There needs to be, I think, sufficient standards and criteria, to be able to prescribe something that's ultimately going to help them. In the same way that there are for numerous other drugs and narcotics that we do prescribe to people that do have exceptions, at least to some extent, or recognize medicinal purposes under the CSA. So I think these are all it's created this maelstrom that I think this act at least tries to address. But what I'm interested here, and you kind of brought this up, is I'm interested to see, what do you think about the states' rights and federalism component of this? Do you think that, and that could even beg the question of is the Controlled Substances Act even constitutional to begin with, which I think there have been some cases surrounding marijuana enforcement and other drug law enforcement, I think based on the Commerce Clause. But do you think that there's a valid states' rights purpose that this law serves?
I think it's really smart to frame it in the way of states' rights. I think some Republicans are still kind of uncomfortable with the idea of marijuana being legal on its merits, but with the states' rights argument, they're like, oh well. The states should have the right to decide whether they want to legalize marijuana or not. So I think it's a really smart frame for Gardner and Warren and everybody else to try to get some more Republicans on board, especially because this is the way the country is going. So I think that in a Democratic administration, if that happens in the next couple of years, this definitely could become law. It was I'm not sure exactly why it did not become law last time. Trump said he would have signed it if it came to his desk. It didn't really go anywhere in the Senate. So I'm wondering if that's McConnell. I'm wondering it's just a lot of GOP. You said, Sessions extremely opposed, and he still has a lot of pull, and he was still AG at that time. So he probably was pushing against that. But it makes me wonder. I think that this States Act or something very similar to that could be law within the next couple of years. I don't know if there'll be federal legislation to just completely blanket legalize marijuana because there's going to be a lot of Republican opposition to that. But using this states' rights argument, which I think makes a lot of sense, I think it's certainly possible that something like this passes, and then you have all these states jumping on because of the revenues that it brings, and the lack of people going to prison for these small quantities of marijuana. So I think there's a lot of benefits, and I think that the states' rights argument is just a very good way to try to convince Republicans to come on board.
I agree. And one of the other things, too, that I thought was interesting is that because this is sort of a halfway approach, if you will, because this doesn't say that, in states like Texas, for example, or other states that have rather strict, even statewide drug policies, that if your state, has not legalized it, number one, the bite of the CSA still is very much real. And two, beyond that, even if your state has, very, very, strict drug laws that those basically are fine. That law doesn't really touch that. So one of the concerns that even pro-legalization advocates I've heard bring up is that, while this law looks good and may be a good compromise, it really doesn't go far enough.
Exactly.
Because one of the issues is that, okay, in a state like, California or Colorado, where it's been legal now for a while, there's obviously a far different approach to, they don't see it as an issue in the way that they may see it in another state.
So can I ask you a question?
Yeah.
So can you speak to what's going on? I mean, so like you said, Sessions repealed the Cole memo. Is the federal government raiding lots of places in these states? Because setting the banking part aside, because that's very important. I mean, the cannabis and marijuana industry has been significantly hampered because they don't have access to credit. So obviously that would have a big impact. But in states like Colorado, for example, how much will it really matter? Because right now it's weird.
Yeah.
But will there be an impact leaving aside the banking issue?
That's a good question. I think that it matters insofar as enforcement, like you pointed out. So the rates of enforcement, I don't know the numbers off the top of my head, but one of the major concerns, at least threats that had been, made by specifically the Sessions Justice Department when he was in power, was that we are going to crack down on, and even under the Obama administration, even with the Cole memo, there was still noticeable prosecution of marijuana cases. So I think that what those states like California or Colorado really have to gain from a law like this is really that idea that they're not going to be, number one, they're not going to be, their citizens aren't going to be violating federal law anymore, which I think is big. And two, that sort of gets any legitimate threats of enforcement from the Justice Department meaningfully and legally off of their back. So I think that they have an incentive in that regard. But
hopefully the SAFE Act also, because the credit issue is huge. That's a real big one.
I agree. Yeah. I think what's concerning though to me is that, again, if this law gets passed, which I think that there's a lot of good elements to it, is because it doesn't go to the extent that you were talking about before, that it could almost be seen as an indirect carte blanche for states that have strict drug laws to really aggressively pursue them, and also could result, depending on what the Justice Department decides to do and who's in power, it could really incentivize them to go after citizens in those states. Which,
that's
again,
really interesting. Yeah,
the makeup.
About that.
And I think that if you look at, and this is bringing mass incarceration back into the discussion, but where you have a lot of states that have significant populations that are incarcerated, or just mass incarceration, looking at it in terms of its connection to the war on drugs and its impact on communities of color, communities with lower socioeconomic status, and the relationship to drug abuse there. I mean, again, those populations really aren't helped by this law. And I think, if anything, it could potentially mean that those, communities could be even more aggressively pursued now that, sort of this issue is quote unquote put to bed. So I think that's one of the big concerns that I think, at least from a policy perspective and from a law enforcement perspective, sort of surfaces with this.
And I could see that happen definitely in some of these very conservative state legislatures and with some of these very conservative governors. I could definitely see that happening, and that would be very negative for that. I didn't think about that. This is some very negative implications.
Yeah, well, I think too, and this is, I guess, sort of where we can sort of conclude the discussion on it. And we kind of touched on this, but some of the broader constitutional dimensions of this law, I think it's, and I'm glad you had pointed it out. about this idea of states' rights, it's really interesting that, the way that this is being framed is invoking, constitutional language, like specifically looking at the 10th Amendment, which I don't have in front of me, and I don't want to butcher the exact reading of the text, but basically has been seen as the constitutional acknowledgement of states' rights, that, those powers that are not, enumerated or endowed to the federal government are going to be, the prerogative, or rather the rights of the states to implement. And those things have, I know, loosely been kind of defined. I think the strongest codification of what that looks like is the state's police power. So regulating health, safety, public morals, etc. Which again, it's a double-edged sword, because you have the states like California and Colorado who really want to, I think, utilize those implied police powers to correct things relating to public safety and health, maybe marijuana being a good medicinal tool, or even just, not enforcing those laws because of the impact it's had on public safety in communities. But also on the other side, you have, states that have very strict drug policies that want to use those laws to uphold things like public safety and health, and public morals too, which is something that is a little bit more controversial in terms of what the state can regulate. But I think this really does create a lot of interesting issues, not only for law enforcement, but also just for constitutional considerations. So any closing bits on this, or I think we captured most of it.
I think you did a really good job summarizing the States Act and the SAFE Act. I'm just optimistic that this will eventually become law, because I mean, I didn't consider your very good point about some states actually taking this as a license to creating even stricter laws, but putting that aside, whether that will happen or not remains to be seen. But I do think that it would be positive, especially with the banking aspect of this, because I keep reading articles all the time about the marijuana industry really being behind, because they just really don't have access to this credit. They have to go cash, and it's just not good. The status quo in this country when it comes to marijuana is just not okay. And I think you walk across state lines with some marijuana, like Colorado, you walk across state lines, you'd be arrested right there. I think so, and that just seems wrong to me. I know states' rights and everything, but I don't know. I think there really should be a consistent policy on this. And obviously, I mean, going back to the start of our discussion about marijuana being not bad compared to a lot of these other
we kind of didn't talk about that, but that goes with
there's a lot of money to be had, and there's a lot of people in prison right now because of this drug that just is objectively not that bad for you, especially compared to, I mean, there's debates about alcohol being, you can't OD from marijuana, for example, but you have alcohol completely legal, and it causes a lot of damage to society too. So, I mean, it's just, it's really interesting, and I am optimistic that attitudes towards marijuana, if you look at polling, have become drastically more favorable towards marijuana legalization. I forget what it's at right now, but it's definitely more than a majority. Yeah,
I'd say at minimum too, decriminalization and reevaluating. I mean, there's even been, I think murmurs on the conservative side about how the drug policies have really had a substantially and noticeably, negative impact on communities of color, and other, demographics where it's really created a major issue. And for me, I guess I'll close on this is just going back to this idea of, even in the status quo, it's just so inconsistent and uncertain, because you could have someone, like Eric Holder or Loretta Lynch under the Obama administration that could take a far more, discretionary or sort of laissez-faire approach, at least as it pertains to the states when it comes to enforcing. But then you can have someone like Jeff Sessions or William Barr that may be very intent on, prosecuting these laws. So it's weird, because then it's it makes the laws almost subject to, what political institutions or groups are in power, which I think is
very bad.
Not really good for the rule of law.
No, not at all.
I guess we'll end on that.
Yeah.
But so thank you to all of our listeners for tuning in. We actually have this recorded, and we'll post this to our website as well. We want to thank again Cornell Radio for giving us the airtime and the space to talk to you guys today. We also encourage you guys to check out our website at www.culsr.org to see recent articles that we've had published from our writers. We usually publish semesterly. We actually have our next issue coming out pretty soon, which we're very excited about because it will be coming out, knock on wood, in physical print. So I want to thank all of our editors and other writers who have put in a lot of hard work to make this organization possible, but also to make our new projects, including this one, possible and successful. I also want to thank Matt as well for joining me here today.
Thanks, Ben.
It's been great. We will be back on Saturday, December 7th at the same time. Until then, I'm Vincenzo Guido.
I'm Matthew Chakov.
And have a happy Thanksgiving, and take care.
Well, when you